Hi, welcome to your Digital Imaging 1 lecture. I'm your instructor, Nancy Boyens, and today we're going to look at some issues relating to copyright law. Okay, there's a lot of confusion about how things receive copyright. So one thing to know is that you own copyright to some piece of artwork that you create as soon as you've created it in a fixed form. Now that means it can't just be in your mind, in your imagination. But as soon as you do something to it, such as perform it in front of an audience or write it down on a piece of paper, you automatically, immediately own copyright to it before it's been registered with any kind of an office. You can, if you choose to do so, register your work with the U.S. Copyright Office, which is in Washington. However, the U.S. also upholds other international laws which protect a creator's rights when something hasn't even been registered. So even if you don't see a little copyright notice, whoever created that original artistic work automatically owns rights to it. And even though those rights haven't been registered in Washington, you should worry that you could be sued for copyright infringement if you use someone else's artwork if you haven't gotten their permission. There have been several different changes in the copyright law. Back in the 1920s, copyright expired 28 years after a work was created. And then in the 20s, they did change the law so that if an artist wanted to renew their copyright, they could do that. In 1976, the Copyright Act changed things so copyright could endure 50 years after the artist's death. So if you think about people like Elvis and the Beatles and they have their recordings that they've made, then their family could still make money off rights to those 50 years after they died. This was amended again in 1998 with the Sonny Bono Copyright Act is what it's called. Officially it's the Copyright Extension Act. And it said that materials can now be held under copyright until 70 years after the creator's death. So if you want to find things that there is no copyright on, and we call that things that are in the public domain, you need to find things sometimes that are very old. Now let's talk again about the copyright notice. It's a good idea to put things on your work that, like the official notice. So you put that little C inside the circle and you write copyright the year 2012 by Jane Doe on the work. If you want to sue someone for using your work without your permission, the lawyers do recommend that you have your copyright registered in Washington, and the Copyright Office does recommend that you follow a set of rules, and that set of rules does include putting the copyright notices on things. But remember I said, as soon as someone creates something, they do own the rights to it. So even if you don't see the copyright notice on anything, you should always assume it is copyrighted. And just go with the thinking, if I didn't create it, someone else did. And whoever created it does own the rights to it. And if I want to use it, I have to find out if I can have permission to do that. Now, some of the way people behave, at times they are breaking copyright law and they don't know it. And other times, what they're doing is protected under an area of the law called fair use. When you share one's work with others, you must do things like have what's called a transformative purpose. Now that means if someone's created a work and everyone is out there sort of talking about it, you have the right to do that. And if you get up and you do a presentation about it, you have the right to criticize it, comment about it. You can do a parody of things. And so some of these things are allowed under fair use. Now let's say the person who created this work wants to sue you. This is going to be decided by a judge, and so rather than there being a statute that says you can or can't do something with a work, all of this is covered under the law in what's called case law. And so the judges rule in a way that they've had a tradition of ruling. But they're going to do several tests to see if you are guilty of copyright infringement. And one thing they'll ask is, did you add something of your own? Like compare this work with the work of someone else. And so in that case, you're adding your own analysis to it. And so your analysis is your own unique thing. And by presenting the work not just by itself, but presenting it alongside this other thing, you have had that transformative purpose. They also look at things like whether or not you deprive the author of profit. So you're less likely to get a suit if you didn't, or lose in a suit. Also, if you show just a portion of an artist's work. So if an artist publishes a book of their paintings, and there are 30 paintings in there, and you happen to show 1 or 2 as examples, you're safer because you've just shown a portion, and you might have actually made the audience interested in this artist's work, and they'd be more likely to go out and buy the collection, rather than, again, you interfering with their profit. You also have a bit more leeway when you are in an educational or a nonprofit setting. Now, in my Photoshop class, what I would like you to do is get used to operating under the principles you would be under if, instead of making things for an educational environment, think about how you would behave if you are doing things for people who are in business to make a profit. So in my class, I want you to make work and think about how you would need to behave if it's for a business and they're going to make money off something like an ad. And if you're in a profit situation, you need to be extra sure that you are using images that you have a clear right to. And you're going to get some kind of written permission from the artist, you're going to buy rights to it, or you're going to find things that are in what we call the public domain. I heard a lawyer discussing the whole fair issue one time, and he said that fair use is more like a defense if he had a client being sued for copyright infringement, but not to think about it as a right. So what I would like my students to do when they make artwork for me, to make it as if they were in that situation where they're making it for the business, who's going to use it to increase their revenue, like advertising. And we're not going to, again, look at the fair use at all. Now, if you look at the way the copyright laws are written, copyright includes the exclusive right to reproduce, publish, and sell the matter and form of literary or artistic work. So let's look at some of the details of that a little more. If you have the exclusive rights, that includes the right to copy or reproduce the work. So you can publish it and put it out there or put it up on your web page. Exclusive rights also includes the right to prepare derivative works, so variations of something. So a lot of my students, what they'll tell me is that they know how to right-click on a photo on the web, save it to their computer, and then if they Photoshop it and alter it, then they don't have to worry about the copyright of the original artist. So let's say you find this photograph of this dolphin jumping out of the ocean, and it's jumped in a certain way, this tail is flipped up, and you just convert that totally to a silhouette, and then you make a logo that has the silhouette of that dolphin. If the artist can still tell, based on that position of that tail and sort of the size this dolphin was, that your logo would have had to have been based on their original, then they can sue you for copyright infringement, because the only one who has the right to prepare derivative works is the original artist, unless they give this right away. So your exclusive rights include the right to import and export the work, the right to distribute the work to the public, the right to publicly display or perform the work, and the right to sell these rights. So do be aware that if you sell these rights to someone else, so you make an ad for the Waco Tribune-Herald and you give them exclusive rights to the artwork in that ad, and you're walking away from it and saying, I'm not going to make any profit from it anymore. If the contract said exclusive right, you may no longer have the right to display it even in your own portfolio, or if you did sort of like a little museum showing of your work. Now, again, if a contract only says exclusive rights, then all these things are covered at once. You do, however, have the ability to make a contract that breaks these issues out separately. And so you could say, I give you the exclusive rights except for the right for me to use it in my own portfolio. So you can retain that.